Well, our first program after the break is Eradicating Sweatshops. The U.S. Department of Labor, Maria Eschavesti and Rolene Otero will make the presentations.
Good afternoon. The Department of Labor's initiative, Eradicating Sweatshops, was born out of necessity. Like many agencies, limited resources, and a huge public workload. In our case, protecting 100 million plus workers. Wage Hour had to find a way to change the behavior of employers. Our old way of doing business, investigations, citing employers, assessing penalties, was not changing behavior. We decided to focus on an industry where we knew the violations were severe and serious, and where the population to be protected was vulnerable, oftentimes an immigrant workforce afraid to look to government for help. Our old way of going after contractors had not made any type of impact on this industry. In the garment industry, we have approximately 22,000 contractors who do the actual production and sewing of goods. They are the employers. But they produce these goods for about 1,000 manufacturers and a couple of hundred retailers. Our challenge was to find a way for manufacturers and retailers to take responsibility for, to become accountable for, to take an interest in what the contractors were doing. How were we to do this? We decided upon a multi-pronged strategy of better enforcement, education, and recognition. In the enforcement area, we took a law that indeed had been on the books since 1938, the Hot Goods Law. And we used it to not just go after the contractors, but to go to the manufacturers and ultimately the retailers. This law prohibits the shipment of goods that have been produced in violation of the law. We do not have to show that the recipient of the goods is the employer. All we have to show is that the goods were made in violation of the law. At first, when we called a manufacturer to say that they were in receipt of goods that had been made in violation of the law and that they could not ship them to their stores, they ignored our calls. A few trips to the courthouse to obtain restraining orders to stop shipment soon caught their attention. After some time of enforcement, of educating them about the Hot Goods Law, two things happened. First, manufacturers ended up coming to the plate and paying the back wages so they could ship the goods. This meant that from an enforcement aspect, we were now recovering wages for workers sooner and faster and more. We also found that manufacturers did not want to hear from us consistently and constantly, and indeed worked with us to develop monitoring programs so they could, for themselves, find out about the problems before we did. But enforcement alone was not going to do the trick. We only have so many investigators. So we also embarked upon a public education program. Working with our public affairs office, we began to name names. We identified to the public and to the industry the manufacturers and retailers who had worked or received goods that were made by contractors in violation of the law. For example, Talbot's, a year ago. Talbot's is a major retailer. Many of us received the catalog. Talbot's, the first time we informed them of their contractor, they ignored us. Just this spring, we found another contractor in violation. At the time we met with them, we also informed the public that Talbot's had received goods. And this summer, they announced, effective August 1st, that all of their suppliers were to have in place a monitoring program. We saw that the heightened public awareness from the Kathy Lee Gifford story to just 2 days ago where the model Kathy Ireland was found having goods made in New York sweatshops, that retailers are now responding in a very positive way. It's true that they didn't do it willingly, but the results speak for themselves. Our enforcement remained the same, that is, we went to the contractor, but we leveraged it by hot goods going up the chain and by publicity. In our Los Angeles garment survey, which we have done both in 1994 and 1996, we have found 50% more shops are being monitored. We are finding that workers on average are getting $1,000 more per year, that 23% more overtime is being paid. We have also developed partnerships. Just this summer, we convened a fashion industry forum where we brought together over 350 people, from designers to workers, to talk about the problem. And what was most amazing was not a single person said there isn't a problem, and that's progress. They worked to find solutions. And just early in August, an apparel industry partnership was developed that is looking at ways at where the industry can voluntarily find mechanisms to assure themselves that the goods are being produced in compliance with labor laws, but not just domestically, also internationally. The concepts that we've used in the sweatshop effort can also be used in some other industries. Indeed, we have already used hot goods to stop the shipment of okra, picked in Texas, and lettuce in Arizona. Indeed, in New York, a law that had been languishing for several years, a state hot goods law, was passed this summer. So we see at this point a critical mass of interest that includes consumers, retailers, manufacturers, that present an opportunity for real and permanent change in this industry. We see our initiative as real solutions for real people affecting their real wages. Thank you.
Thank you. Are there questions from, yes, we'll start with Dick, and Max next, and Jack.
Do you have any numbers that describe the effectiveness of your program?
Well, as I said, we have undertaken, one of the hardest things is finding data. And in this case, the test of compliance is not just simply looking at how many investigations you've done. What we did in 1994 and again in 1996 was to undertake a random survey of contract shops in the Los Angeles area. I must caution that this was a survey taken from a universe of registered contract shops, which means that you're not including all the underground shops, but at least it's a picture. And what we found at that time was, in 1994, close to over 65% were not paying overtime. In 1996, a little over 50% were not paying overtime. In 1994, over 55% were not paying minimum wage. In 1996, a little over 40% were not paying minimum wage. I want to note, those are not good numbers in and of themselves, but what we see is some impact.
Max?
I'd like to add just one thing, that we did a statistical analysis of this report, and the overtime difference between 1994 and 1996 is at the 99% confidence level that in fact we have made a difference. When we look at all the variables that are available that might have made a difference in this industry, the one that is the most indicative of a change in behavior is a manufacturer monitoring their contractor for labor law compliance.
One of the things that comes out in looking at the material is that for about 50 years, this was not an impressive record under the Fair Labor Standards Act in trying to deal with this problem. And this is a major effort to address it. But a concern that comes through is that in working with manufacturers, you actually have a compliance agreement, which, as I understand it, is about 19 pages, single-spaced, and is almost as formidable as some of the things that prevented the agency or the department from doing things in the past. Are we getting ready to reinvent some of those obstacles? It would seem to me that's a critical concern.
It is a very critical concern to us, and indeed what happens is with many government agencies, people take a proprietary interest in the products that they've developed. Some of our attorneys and staff believe that 19-page single-space legal document is the only way to do monitoring. And instead what we've done at the higher level is say, bring in all the different types of monitoring, distill them into sort of the key elements, and then work with each manufacturer or retailer for them to decide what works best for them. And that's exactly what we're doing. We're not wedded to a particular way.
Before I ask Jack to ask his question, do you have any examples of manufacturers, key manufacturers and retailers who, of their own initiative, have led the way to try to improve these conditions?
Well, we certainly do. In fact, one of our projects in December of '95 was to identify retailers and manufacturers who had, without prompting from us, had already in place programs to either monitor or to assure themselves that their goods that they were selling were being produced in compliance with the laws, and among them include the limited, Levi Strauss. Our task is that there's always a small group of people who sort of are forward thinking, and our real challenge is the majority of manufacturers and retailers. Pauline?
In the survey that we did this year, 47% of the contractors were being monitored by their manufacturers. We only have 40 manufacturers out of 1,000 in Los Angeles which are signed up on direct agreements with us, which is less than 10% of the population. So clearly, a great number of the manufacturing population has begun doing monitoring without being required to do so by the Department of Labor.
Just as an aside, you mentioned Levi Strauss, the chairman of that company is a trustee, a present trustee of the Ford Foundation. Jack, for your question.
He's monitoring and he's not required.
With all respect to the intelligence of going after the wholesaler rather than the fly-by-night little factories, help me understand an economic point that's way outside your realm. The reason for these kinds of sweatshops is to keep the price down. Keep the price down because it's a vastly competitive global market. To the extent that you succeed, and a lot better in this way than you used to, in avoiding sweatshop wages, I would guess you drive the price up. And to the extent that you do that, don't you drive those jobs to Indonesia?
That has been two very often asked questions. Number one is, our analysis is that the actual labor cost, the labor that goes into making a product is less than 10% of what you pay in the store. So that compliance with labor laws, if you kept all the other factors, the marketing, the production, the labeling, the distribution, would add to a $29 shirt another $1.25, if all things stayed equal. So in terms of huge cost, we don't see that quite as stark as some have painted it. But in terms of driving jobs overseas, the Kennedy School and the School of Economics, Professor Dunlop has an apparel garment task force, which we have consulted with quite a lot. And one of the things we've noticed is that because of the new way of doing business, retailers, they don't have huge warehouses, they do rapid replenishment. They need to find producers who can produce the goods quickly, and that is why we have seen a reemergence and a stabilization of the garment